But returning to the criminal law, in the criminal law of the continent, this is the Continental Law up till recently was based on late Roman law. It was based on the reforms of the Emperor Justinian. And he was, as the late emperors were, an absolute emperor. And he brought in a draconian legal system, which was then resurrected across Europe in the 14th, 15th, 16th centuries. And it basically said, all power is with the state. And if the state thinks that you are guilty of some offense, there's hardly any chance you'll get away from it. Because the state prosecutes, you have prosecuting magistrates, you have the same person who is both the judge and the policeman looking at the case. We separate, we have the judge, the police, the jury, and so on. So in the system in China, for example, the Mandarin who's trying the case will also be the person who's the detective and finding it out. Mm. I mean, there's a famous book, which is a delightful book called Judge D. And this is a set of novels by an English writer, but it's based on original materials set in 8th, 9th, 10th century Tang, China. And it shows the use of torture and all these other things, because basically what the judge is trying to do is to find out whether you're guilty. And the best way to do that is to torture you, or to torture your friends or your family, or to confiscate your property. Another way in which the law is enforced there is the notion of group responsibility. In China, for example, or Japan, if you're found guilty, then not only you, but your parents, your children, your cousins, all of you will be either tortured or thrown in, not usually prison, into kangs, because prisons are expensive. So you'll have a wooden thing put round your neck, or you'll be outlawed or banished or beaten severely with a wooden rod. A whole 20, 30. And if it's an extremish case, then the whole village will be destroyed for one person. So there is a big pressure from others and your family not to do anything wrong, because everyone will be implicated. Now, in that system, there is, as I say, no protection. The English legal system is miraculous because it has two kinds of protections. One is the famous writ of Habeas Corpus, I have a body, which is 12th, 13th century writ, which basically says, I have a body and I have the right to maintain the freedom of that body unless I am found to be guilty. So the presumption of innocence and the right to go to get a lawyer to come in and defend you and so on, and to have your case tried quickly and not just be thrown into prison forever until the case is brought. All those stem and are associated with habeas corpus, and that gives a huge protection to each individual. And the other part of the protection, which is even more miraculous and wonderful, and people really don't consider this, is the jury system. Now, this is an Anglo-Saxon system and developed from then onwards. And basically what it says is, you have the state on this side, which is terribly powerful, have the individual, the lone individual here. To protect that individual, you have a system whereby there are 12 people selected from people who are independent of the state. They are rich enough, they're educated enough, they have enough self-confidence so that they're assembled. When a case is tried, the Crown puts its accusations to the jury. So you have to persuade 12 people who are not relatives of the accused, but they are independent. If you can persuade them, then the person will be found guilty and then the judge will give the sentence. but it's a high bar because you have to persuade rational, independent people that there is enough evidence. And the rules of evidence are carefully laid out. I mean, if you look at Chinese or French or other courts, there are hardly any rules of evidence. What constitutes real evidence? Is hearsay evidence? Is some apparition from a ghost evidence? Whatever. But in English legal texts, you have the rules of evidence, you have the procedures laid out carefully. And we have a double jury system. We have the grand jury, who first of all says, is there a case to try? And then you have the petty jury, which says, is the person innocent or guilty? And then finally, you have the judge. And again, there is a protection because in most legal systems, the judge is just another minion, paid by the crown, appointed by the crown, dismissed if they don't do what they are told. But we have preserved an independence so that judges theoretically are independent of everyone. They were obviously independent of bribery, which was a big problem in most systems, because they were paid very well indeed. And they even took the precaution that when they went on their circuits, the judges, they went to a special house which was preserved, or in Cambridge to the master's lodgings in Trinity College, wherever, which was sealed off during the time of the trials, so that no one could come and say, how about this money if you do that? So the judges were independent and they stood up to the crown, as famously during the Civil War and so on. So basically, as one of our greatest judges, Cook, said, if you live in a country which is not filled with fear of sudden arrest and sudden torture and sudden death, you can go freely on your ways. Thank God for the ancient laws of England, because it protects you. In every other civilization, the knock on the door in the middle of the night was to be feared at any time. So that is the miracle of the system that we have had. Now, of course, it is even less apparent because much of English law has been absorbed into European law, and you have due process and you have assumptions of innocence until proven guilty and so on. Scotland is interesting in that respect because they have a slight difference still in that their law has this category of not proven. In our case, if you are found not guilty, you are not guilty. In Scotland, you have not proven guilty, which leaves you in a kind of vague limbo. And that's another thing that is worth mentioning that many people don't know, that Scottish law is quite different from English law in many respects, and traditionally was much closer to continental law. For example, it used torture, which is why the Scottish witchcraft cases were much more horrendous than the English ones, because there was a use of torture.